Hafa Day to my people of Guam. Merry Christmas, and thank you all for being here. I'm joined here by my fellow Senator Sabrina Salas-Manzanani. We are on a open roundtable with the doctors that be invited to come to this roundtable to discuss medical malpractice reform. But it seems like currently there are no doctors that want to talk about medical malpractice today. And so we will, at this time, just give a brief overview about what this bill is about, what this roundtable was supposed to be about, and hopefully the people of Guam can go into the holidays a little bit more educated about one of the more pressing problems in our community today. So once again, Hafa Day to the people of Guam, and thank you to everyone that is here. My fellow colleague, Senator Sabrina Salas-Manzanani, thank you for being here. And the bill we're discussing today is Bill 82-38, the Do No Harm Anti-Medical Misconduct Act of 2025. This proposed law aims to reform Guam's medical malpractice system, particularly the mandatory arbitration process that has governed malpractice claims for decades. To appreciate why reform is on the table, it's important to understand how Guam's medical malpractice system evolved, what the current system looks like, and why change is being considered. In the 1970s, Guam, like many jurisdictions, faced rising medical malpractice insurance costs and concerns about frivolous lawsuits. In response, the legislature enacted Public Law 13-115 in 1975, which for the first time required malpractice claims to undergo a pretrial arbitration or screening process. However, the first attempt at a malpractice claim system did not stand for long. In 1984, the Ninth Circuit of Appeals, applying the Organic Act as Guam's constitutional framework, struck down that 1975 law in a landmark case, Awa versus Guam Memorial Hospital. The court found Guam's original mandatory malpractice arbitration scheme unconstitutional, citing internal inconsistencies and infringements on the right to a jury trial. In short, Guam's initial system was deemed inorganic and unenforceable by the courts. After the setback, Guam was left without a special malpractice claims procedure for several years. By the late 1980s, medical liability issues were again reaching a crisis point, with skyrocketing insurance premiums and doctors practicing defensive medicine to avoid lawsuits. The current system was born out of this crisis. In 1991, the 21st Guam legislature passed Public Law 21-43, known as the Medical Malpractice Mandatory Arbitration Act, as a comprehensive fix. This 1991 law repealed the old unconstitutional statute and replaced it with a new framework designed to provide prompt and effective resolution of medical malpractice claims. Under Public Law 21-43, which remains in effect today, any medical malpractice claim in Guam must first be submitted to a private arbitration panel before it can reach court. In practical terms, a patient alleging malpractice cannot simply file a lawsuit in the Superior Court. They must initiate a proceeding with a panel of 3 arbitrators, often under the auspices of the American Arbitration Association or a similar body. Only after this arbitration is concluded, and only if the outcome is unsatisfactory to one of the parties, can the case move to a courtroom. And even then, there are cost penalties if the trial result is not markedly better for the party who appealed the arbitration. This mandatory arbitration process has been in place for 34 years, shaping how malpractice victims and healthcare providers seek justice. Today, the Guam medical malpractice system is at a crossroads. The 1991 mandatory arbitration law was enacted to address fears of excessive litigation and high insurance premiums. But critics now argue, however, that this system has made it too difficult for injured patients to hold providers accountable. They point out that arbitration can cost claimants thousands of dollars upfront and introduce significant delays. A poignant example came in 2018 when a grieving father, David Lebowski, sought justice after the death of his 5-year-old son. His struggle drew public attention to the barriers patients face under the current system. Supporters of reform contend that Guam's law, intended to streamline disputes, has instead become a barrier to justice, effectively discouraging or preventing many valid claims from ever being heard in court. On the other hand, Guam's medical community emphasizes that the current arbitration system was meant to protect our healthcare stability. They worry that repealing mandatory arbitration could lead to a flood of lawsuits, higher malpractice insurance costs, and difficulties in recruiting doctors to Guam. It's important to acknowledge these concerns. In summary, Guam's medical malpractice system has come full circle in the past few decades, from an initial attempt that was struck down to a long-standing arbitration regime now under scrutiny. Bill 82-38 proposes to reform the system once again, aiming to restore direct access to the courts while still filtering out unmeritorious claims. My goal today is to walk through the history that brought us here, the details of the current law, how Guam approach compares to other U.S. jurisdictions, and the argument for reform drawn from our experiences and constitutional principles at stake. To make informed decisions, we must look carefully at the legislative and judicial timeline of Guam medical malpractice laws. The timeline reveals recurring themes of trying to balance patients' rights with the need to maintain affordable health care on our island. In 1975, Public Law 13-115 was Guam's first comprehensive malpractice law that was enacted on December 23, 1975. This law created a mandatory pretrial screening and arbitration process for malpractice claims. Although the exact mechanisms aren't always remembered today, it is clearly intended to curb costly litigation by diverting claims into an alternative dispute resolution process. Essentially, before a patient could sue a doctor or hospital, a claim had to be presented to a designated panel of arbitrators. This was part of a wave of the 1970s tort reform efforts seen in various U.S. jurisdictions to tackle a malpractice insurance crisis. Then from 1980 to 1984, there were legal challenges. Almost immediately, Guam's mandatory arbitration scheme faced constitutional challenges. Patients and attorneys argued that forcing claims out of the courts infringed upon fundamental rights. And after winding its way through the courts, the issue reached the federal appellate level. In 1984, the Ninth Circuit decided Awa versus Guam Memorial Hospital, holding that the statute requirements were incompatible with Guam's Organic Act and laws. Notably, the courts found that the law contained mutually incongruous and incompatible provisions, and more importantly, violated the right to a trial by jury for civil litigants. Guam's Organic Act, our de facto constitution, guarantees the same fundamental rights as the U.S. Constitution, and while the U.S. 7th Amendment right to jury trial in civil cases doesn't automatically apply to territories, Guam had its own statutory protections. The 1975 law's mandatory arbitration and screening panel requirement effectively deprived plaintiffs of their day in court, which the Ninth Circuit deemed unacceptable. Guam was left without a functioning malpractice claims process for several years. The interim period, in the wake of AWA, malpractice claims on Guam proceeded like any ordinary civil tort case. No special arbitration requirement existed at all. During this period, doctors and hospitals grew concerned that the lack of any screening mechanism would invite frivolous lawsuits and drive up insurance premiums. At the same time, patient advocates and trial lawyers noted that at least now victims had an unfettered right to sue in court. Guam watched as many states experimented with different malpractice tort reforms. Some imposed caps on damages, others created medical review panels. And some, like California, relied on voluntary arbitration agreements between patients and HMOs. Guam needed its own solution that would pass constitutional muster. So, come 1991, Public Law 21-43 becomes enacted. That's the law we have today. After expensive debates, the Guam legislature passed Bill number 325 COR, which along with the acting governor signed into law on September 8, 1991 as Public Law 21-43. Repealed the remnants of the old Public Law 13-115 and enacted an all-new Chapter 15 of Title X of the Government Code, completely overhauling the medical malpractice system. The new law was explicitly titled the Medical Malpractice Mandatory Arbitration Act. It sought to remedy the flaws of the old scheme and create a workable process that could survive court scrutiny. In the legislative transmission to the Speaker, the governor noted that he signed Bill 325 into law for the benefit of Guam's healthcare system. So we will delve into the law's content in the next section, and suffice to say here that Public Law 21-43 reintroduced mandatory arbitration, but with significant procedural safeguards, like the option of a trial de novo in court, intended to protect litigants' rights. In 1992, this was codified in the Guam Code. Provisions of Public Law 21-43 were later codified as Title 10, Chapter 10 of the Guam Code Annotated for anybody that wants to look more into it. For reference, 10 GCA 10102 is the section that mandates arbitration for any malpractice claim in Guam, stating that any claim shall be submitted to mandatory arbitration. If it involves allegations of medical negligence, the law applied equally to private and government healthcare providers and included a severability clause to ensure that if any part was found unconstitutional, the remainder would survive, a direct response to the total invalidation of the 1975 law. In 2003, there were court challenges, La Guatna versus Guam Memorial Hospital. Fast forward a dozen years, by the early 2000s, some plaintiffs began to test whether 21-43 was truly constitutional in practice. In a notable 2003 case, often referred to by the parties named La Guatna or Villagomez Palizon, the Guam Superior Court ruled that the Mandatory Arbitration Act was inorganic, this time on different grounds. The trial judge found that the law violated the separation in powers and denied access to the courts in some instances. The judge's reasoning was that requiring an expensive private arbitration as a precondition to a court case can prevent the courts from ever hearing meritorious claims, especially if a plaintiff cannot afford the upfront cost of arbitration. The court also voiced concern that the act delegated judicial power to arbitrators, private citizens, to make binding decisions, raising separation of power problems. This ruling sent shockwaves. If it stood, Guam's entire system would be struck down again. The defendant medical providers swiftly appealed via extraordinary writ, and the case reached the Guam Supreme Court, which by then had been established as the island's highest court. In 2004, the Guam Supreme Court overturned the Superior Court's decision, thereby upholding Public Law 21-43. At least respect to the separation of powers as issues. The Supreme Court issued a writ of mandate holding that the Mandatory Arbitration Act does not offend the separation of powers doctrine of the Organic Act. It is worth noting, however, that the Guam Supreme Court did not rule on other potential constitutional challenges in that case. The plaintiffs had also argued that mandatory arbitration infringes on the right to a jury trial, on due process, on equal protection, and on the right of access to the courts. Those arguments were left undecided. Undecided. The justices explicitly declined to address whether the Arbitration Act might violate a plaintiff's right to jury trial or other personal rights, since that would require further actual development. In other words, the door was left open for future challenges on those grounds, though none have definitively reached the Supreme Court since. In 2021, discussions of reform emerged as growing public sentiment started to change and discussions started to happen. In 2019, Speaker Tina Rose Muñoz-Barnes introduced Bill number 248-35 LS, which was an access to medical arbitration fund approach. It creates a new funding mechanism called the Access to Medical Arbitration Fund by adding a new Chapter 10A to Title 10 GCA, increase revenue into that fund by establishing new fees tied to application for health professional licenses. It would seed the fund immediately by appropriating $100,000 from the unappropriated general fund balance at the end of FY 2019 as an initial deposit. The bill's intent was to reduce access barrier created by the upfront costs of mandatory arbitration by creating a dedicated pool of money that could be used to support participation in the arbitration system. However, the bill was withdrawn on May 22, 2020. In 2020, Bill number 430-35 LS was introduced by Senators Therese Terlahi and Tello Taitigui, which would replace Guam's MMM-AA structure with a less costly pre-trial screening model described by the sponsors as a replacement for the nearly 30-year-old Arbitration Act. The sponsors described the process where a claimant could file in court and a magistrate judge would determine whether there's enough evidence supporting a conclusion that the provider failed the standard of care. The magistrate judge could keep the complaint, proceedings, and opinions sealed for a period after issuance with potential extensions, particularly if no trial is pursued. The bill was introduced against the backdrop of a court question about whether arbitration requirement should be excused when an indigent party cannot afford non-administrative arbitration costs and no alternative path exists. It was introduced and tracked, but it did not become law in that term. In 2021, Bill number 112-36 was introduced by Speaker Therese Terlahi, Tello Taitigui, Joanne Brown, Tina Rose Muñoz-Barnes, Joe S. San Augustine, V. Anthony Ada, Talida Cruz Nelson, Christopher M. Duenas, Clinton E. Rigel, Amanda L. Shelton, and Jose Pedro Terlahi, and Sabina Flores Perez, which would again amend the existing medical malpractice framework to replace extensive arbitration with a government-funded mandatory pre-screening process for claims involving personal injury or death due to alleged malpractice, directly addressing the indigency problem identified by the courts, because that existing mandatory arbitration law did not explain what happens when an indigent plaintiff cannot pay half the arbitration costs. And it quotes Chief Judge Maglonia's concern that enforcing that requirement against those unable to pay would be unfair and would be effectively bar the poor from justice. Bar the poor from justice. Before filing for a pre-screening, a claimant must give the provider at least 45 days notice of intent to file. Nothing would prevent a provider from communicating with the claimant during notice period to attempt resolution via mediation, arbitration, or other legal processes. Allows a provider to make an offer of reparations before pre-screening, with whose communications treated as privileged and not usable to prove liability or measure damages attributable to the offer. The substitute version followed public hearings and was advanced for further posting and public hearing roundtable considerations in late 2022, but ultimately did not become public law. Bill 82-38, that brings us to today. Bill number 82-38 proposes to eliminate the mandatory private arbitration requirement and instead implement a new pre-litigation process with the court system. Essentially, rather than paying 3 private arbitrators, a malpractice claimant would file in court and a judge would conduct an early interview, a screening conference or hearing, to determine if the claim has sufficient merit to proceed. This approach is inspired by practices in certain U.S. states, which I will compare shortly. Through this timeline, we see a cycle of attempt, challenge, adaptation, and now reconsideration. Each key event, the 1975 law, the 1984 Awa case, the 1991 reform, the 2004 court decision, reflects the tension between the two objectives: ensuring fair compensation for those harmed by medical negligence and preserving a stable, affordable healthcare system for the island. Bill 82-38 is simply the next chapter in this story, aiming to recalibrate the balance. Public Law 2143 was explicitly crafted as Guam's solution to malpractice insurance crisis of the 90s. The intent was to create a system that would quickly resolve claims, weed out non-meritorious lawsuits, and control legal costs, thereby stabilizing the malpractice insurance system. As noted in the committee reports that accompanied Bill 325, Guam faces a crisis of medical malpractice claims, with insurance leaving and premiums becoming prohibitive. The legislature response was to establish a prompt and effective resolution process. In fact, those words, prompt and effective, were part of the title and findings of the law. Lawmakers hoped that by channeling all claims into a streamlined arbitration, case would be resolved in months rather than years, reducing the cost arms race of litigation. In essence, Public Law 21-43 created a mandatory arbitration system with an escape valve. Every malpractice claim must go through arbitration first, which ideally filters and resolves disputes more efficiently, but if either party feels truly aggrieved by the arbitrator's decision, they can still have their day in court, jury trial and all, with the proviso that they risk paying the other side's legal bill if the court outcome is not markedly better. So there were a lot of legislative debates from when Public Law 21-43 was passed, because they shed light on the law's purpose. Senator Dr. David Shimizu, who chaired the Health Committee in 1991, led the effort on Bill 325, and the committee report indicates that the legislature was keenly aware of the previous law's failure and sought to avoid the same mistakes. For instance, the report acknowledges Public Law 13-115 was struck down by the courts for being incompatible with Guam law. So the new bill was carefully written to cure those defects. During the public hearing on Bill 325, various stakeholders gave input, which resulted in amendments to improve the bill. Local physicians urged that the standard of care definition reflects Guam's context, which was adopted. There were suggestions to ensure that arbitrators are familiar with Guam, hence the requirement that 2 arbitrators reside on Guam. The Guam Bar Association and others recommended allowing either party, not just defendants, to make an offer of reparations. That is confidential and cannot be used against them later. Initially, the draft only protected offers by respondents. It was made fair by covering claimants' offers too. Concern was expressed about arbitrators crafting complex remedies like ordering future medical services, which could lead to disputes. The legislature responded by limiting awards to monetary damages only. To avoid any legal conflicts, a controlling statute clause was added to clarify that where the arbitration law might conflict with other Guam laws, the provisions of the arbitration law would generally control it unless explicitly contradicted by another prevailing law. So has the law worked as intended? In some respects, yes. Guam has not experienced the kind of explosive growth in malpractice lawsuits that some feared in the 1980s. In fact, very few malpractice cases have reached a full jury trial on Guam in the past 30 years, because most are resolved at the arbitration stage or not pursued at all. Malpractice insurance for providers became available again in the 1990s, and while premiums are still high, we haven't seen the acute crisis of unavailable coverage that prompted the initial law. The existence of the arbitration requirement has likely caused plaintiff's attorney to screen cases more rigorously, taking on only those that have enough merit to justify the cost of arbitration. However, it is also clear that the law has unintended side effects. Some have called the process cumbersome and time-consuming, noting that it essentially duplicates efforts. And while the threat of fee shifting is meant to discourage unnecessary trials, it may also discourage patients from exercising their right to a trial, even when arbitration yields a low award. They might settle for less than they deserve out of fear of the 40% rule. There are some of the concerns that motivate current reform efforts. In summary, Public Law 2143 was well-intentioned, carefully engineered system, and it served its purpose for many years. Yet our experience under it, along with evolving legal norms, suggests it may now be time to modernize our approach once more. Bill 82-38 seeks to do just that by learning from what worked and what didn't in the 1991 law. So let's compare Guam's malpractice system to other systems. Guam's requirement is, in a word, unique. No U.S. state currently has a blanket requirement that all medical malpractice claims go through binding arbitration before a lawsuit. Guam truly stands out as exceptional and unique in this regard. Here's a comparative overview of what other states are doing. In terms of screening panels versus arbitration, while states don't impose universal arbitration, many states do require some form of pretrial screening or review of malpractice claims. According to the National Conference of State Legislature, as of 2021, 17 states and territories, including places like Alaska, Hawaii, and Massachusetts, Nebraska, and others, require malpractice to be presented to a screening panel before trial. These panels typically consist of medical experts and sometimes lawyers or retired judges who review the evidence and give an advisory opinion on whether the claim has merit. Then there are also voluntary arbitration agreements. A number of states encourage these type of agreements. For instance, California law allows healthcare providers and patients to voluntarily agree to arbitrate any malpractice disputes. These agreements, when signed, are binding and waive the right to trial, but they are not mandated by state law. It's a contract between patient and provider. Guam's approach, by contrast, is compulsory by statute. No agreement of the parties is needed, and it is not optional. A major way Guam differs is that we do not have statutory caps on malpractice damages, such as a limit on pain and suffering awards, where many states do. For instance, California's MICRA law caps non-economic damages at $250,000. Guam has never enacted a cap on malpractice damages, and our reform path was focused on procedure rather than limiting compensation. This arguably made the arbitration requirement even more significant to providers as a shield, since a large jury award is possible if a case gets to court with no cap. Over half of U.S. states now require a plaintiff in a medical malpractice case to file a certificate of merit or expert affidavit at the outset of a lawsuit. This means that a qualified doctor must sign an affidavit stating that the claim has reasonable merit before the case can proceed. Guam does not have a certificate of merit law currently. What Bill 82-38 proposes for Guam, replacing private arbitration with court-based pre-litigation screening by a judge, is not unprecedented. A number of states have variations of early judge-led evaluation. For example, some states allow either party to request an early summary judgment on merit or a preliminary hearing on whether the standard of care was breached. Maine has a pre-litigation screening panel. New Hampshire uses screening panels whose findings can become known to the jury under certain conditions, unless both parties agree to waive panel. In the vast majority of U.S. jurisdictions, if a patient files a malpractice lawsuit and meets procedural requirements, the case proceeds to trial by jury if not settled. The right to have a jury decide the case is usually sacrosanct. protected by state constitutions. Guam's current law technically preserves jury trial through de novo option, but in practice, the financial and procedural hurdles mean very few cases ever make it to the jury. So one could argue Guam's system has functionally fewer trials for malpractice than almost anywhere in the U.S. The reform proponents assert that allowing cases directly to court would restore the possibility of a jury trial for malpractice victims, bringing Guam back in line with the norm of public adjudication of these disputes. We've used the courts for hundreds of years. These judges have ruled on cases for hundreds of years, and suddenly it's not acceptable anymore. And other systems show that they can be workable systems. But many fear that without something like our arbitration law, malpractice lawsuits will multiply. However, looking at other states can be instructive. States with only mild reforms have not necessarily seen runaway litigation. A lot depends on the broader legal culture and insurance environment. For instance, Hawaii's system with a pre-filing conciliation panel, no caps, has led to an overwhelming number of malpractice suits relative to its population. Nebraska, which uses pre-suit panels and a cap on damages, has very few claims. Indiana's panel system has been credited with stabilizing rates, but has also been critiqued for adding delay. In essence, Guam's law is one of the most stringent in funding malpractice claims away from the courtroom. It was a trailblazing approach in 1975 and again in 1991, but it is not in the mainstream of U.S. malpractice systems today. The trend elsewhere has been to integrate expert review and mediation within the judicial process, not replace it, rather than supplanting it and entirely with private arbitration. Guam's Bill 82-38 is in many ways an effort to align our process more closely with the states by moving the initial screening function into the court system under a judge's purview and removing the absolute roadblock of mandatory arbitration. The challenge for Guam is to find a system that is fair to patients and still attractive enough for doctors to confidently practice here. That's why any reform like Bill 82-38 tries to include safeguards similar to what other states use. Finally, I want to articulate the arguments for reforming Guam's medical malpractice law, drawing on our historical experiences, known inefficiencies in the current system, and the constitutional values that have been raised in past debates. The most compelling argument for reform is that the current mandatory arbitration system can deny or delay justice for those who have been harmed by medical negligence. As lawmakers and public servants, we have to ask, is the system working for the people it is meant to serve? There is considerable evidence that it is not. Under the current regime, if an individual or modest means believes they or a loved one were injured by substandard medical care, they face a formidable hurdle. They must front potentially tens of thousands of dollars in arbitration expenses just to have their case heard. Arbitrators' fees, administrative costs, and expert witness fees all come before one ever sees a courtroom. A superior judge in 2003 highlighted this very issue, noting that many litigants will lack the ability to first submit to arbitration due to the high initial costs, effectively preventing legitimate claims from ever being adjudicated by any court. Reform would remove this financial barrier by allowing cases to be filed in court and having a judge oversee early screening. The upfront costs shift largely to the defendants, hospitals, doctors, and their insurers, and the public court system rather than the individual patient. Our courts are a public resource. Using them for initial evaluation costs the victim far less than hiring arbitrators. We do have the arbitration fund now to help poor claimants, which is an acknowledgement of the problem, but requiring people to seek government aid simply to bring forth a malpractice claim indicates the system's inherent inequity. A fundamental principle of American justice is the right to have cases disputed by a jury of one's peers. Guam's Organic Act and laws embrace this principle. Our original laws fell because it violated that right. The 1991 law attempted to preserve the right by adding the trial de novo option, but in practice, how many malpractice claimants on Guam have ever gotten a jury trial? The number is exceedingly small. The trial de novo mechanism, while constitutionally clever, places multiple disincentives on actually using it. From the cost of a second proceeding to the fee-shifting penalties if the trial doesn't vastly exceed the arbitration award. One can argue that the current system satisfies the letter of the law, but not the spirit. This was implicitly recognized by the Guam Supreme Court when it pointed out that it had not resolved whether the act might infringe on the right to a jury trial, due process, and equal protection. Because those issues were not squarely before it. The very fact that those issues were raised signals that mandatory arbitration scheme walks a fine line. By reforming the system to remove mandatory arbitration, we fortify the constitutional right side of the equation. Under Bill 82-38, every claimant would ultimately have the ability to go to a trial, jury or bench, once the court conducted screening is done. No private entity can stop them from having their case heard by the judiciary. The current system's two-step process can be seen as inefficient, especially in cases that ultimately end up in court anyway. Bill 82-38 aims to streamline dispute resolution by having a judge do an early review. We can achieve the same goal of filtering out weak cases without incurring the full cost of a private trial. If a case passes the judge screening, it proceeds to discovery and trial. One comprehensive process, not two. If it doesn't pass, it may be dismissed earlier, saving everybody time and money. And because the screening is done by a judge, the outcome can be a matter of public record, possibly guiding future parties. Arbitration decisions, by contrast, produce no public record or precedent or guidance, so they have to be relearned each time. There is a broader, less quantifiable argument, and that is the public confidence in the system. And I think that's where a lot of us really come down, is we have a lack of confidence in the system. Over the years, I've spoken with many constituents who, rightly or wrongly, feel that the mandatory system is stacked against the patient. And perceptions matter. By bringing malpractice adjudication back to the public courthouses, we reassure the community that these cases will be heard in an open forum by neutral judges, and if it goes to trial, by jurors from the community. This transparency can improve trust. If a claim truly lacks merit, it will be thrown out by a judge or defeated in court, but everyone can see that justice was done. If a claim has merit, the patient will get their day in court without undue hurdles. The status quo defenders say, if it ain't broke, don't fix it. But patients and their families say, it is broken. It is broken for those that need it most. And the truth probably lies somewhere in the middle. The system works for some purposes, but is failing in others. An often overlooked benefit of making it easier for valid claims to be heard is that it promotes accountability and patient safety. If the pendulum swings too far towards insulating providers from lawsuits, there is less external check on negligent practices. Our current law was accused of just doing just that, favoring healthcare providers over patient rights. With virtually no malpractice trials, there's arguably less incentive for some bad actors to improve. By recalibrating the system to allow more legitimate claims through, we reinforce the idea that negligence will have consequences, which is a cornerstone of torts law deterrent effect. We do not want frivolous lawsuits, but we do want doctors and hospitals to strive for the highest standard of care, knowing that if they do make preventable errors, they may be held accountable in court. Striking that balance is key to a high-quality healthcare system. In making the case for reform, I want to emphasize this is not about attacking healthcare providers and enriching lawyers. It is about correcting imbalances that have become apparent for 30 years of experience. The arguments for reform stem from an understanding that a system too far tilted in favor of one side eventually erodes public trust and may falter. Doctors would never trust a system that ruled 100% in favor of the patients. So why should patients trust a system that rules 100% in favor of a doctor? Historical challenges show the dangers of going too far in cutting off rights. Inefficiencies and costs have shown the system can be self-defeating at times. Constitutional principles remind us that our justice system should be open, accessible, and ultimately decided by the people and the jury when appropriate. To conclude the case for reform, by adopting Bill 82-38 or a similar measure, Guam can address the current weaknesses of the current law while preserving its strengths. We can keep what worked, for example, preliminary checks or claims, but shift it to be a more constitutionally sound arena. We can remove financial barriers while possibly implementing new safeguards. The reform is not about increasing lawsuits. Nobody wants to see more lawsuits, but it is ensuring worthy cases aren't shut out. It is about reforming our legal system so that it exists to serve the people, both patients and doctors, fairly and transparently. And I believe we can achieve a middle ground. So, colleagues, I thank you for listening to this comprehensive overview, and the people of Guam for coming to my TED Talk. It's very, very long, but I hope it gave people an understanding of what the stakes are and where this all came from, because this is not a new conversation. This has been a conversation that has been going on for decades. And Guam's medical malpractice system can be reformed and must be reformed to better serve all of our people. With Bill number 82-38, we can have a starting point for that change. And I was hoping to urge constructive dialogue on how we can pay for arbitration costs so that the indigent are barred from justice. And I want to hear from the doctors what they would say about it. And I'm sorry, before I continue, I'd like to introduce my colleague, Senator CITE. Thank you for joining us today. And Senator Tony Addo was here earlier. He came in the middle of my spiel, and I didn't get a chance to introduce him, but I'm sure he'll be right back. Right now, I want to open up the floor to my colleagues. If you have anything to say or talk about, please do. This is the time. This is for people to speak, and then I will allow this gentleman from the community to come up and have 5 minutes to, say his piece since he came all the way down here. So, Senator,
thank you, Senator Parkinson. Well, at the heart of the discussion are patients and families who've experienced harm and are seeking accountability. During the initial hearing on Bill 82, much of the testimony we heard was emotional, personal, and focused on patients' experiences. Those voices must remain central as we consider any changes to our medical malpractice laws. And Bill 82, it is intended to strengthen patient protections and bring greater accountability to these sorts of cases. And those goals are important. Patients who are harmed deserve a process that is fair, accessible, and affordable, and capable of delivering justice without unnecessary delay or cost. At the same time, we also should consider input from our physicians and their concerns, not just only with this bill, but in previous informational briefings and roundtables that occurred in past legislatures. And this bill is similar to Bill 112 that was introduced prior. And some of the concerns that I heard that this bill applies unevenly across our healthcare system. GMH physicians remain protected under the Government Claims Act, including a statutory liability cap, while private physicians face expanded procedure procedures, sanctions, and uncapped liability. Two physicians practicing the same medicine should not be treated differently based solely on where they work. In addition, there were concerns during the public hearing on Bill 82 that were raised by the judiciary of Guam. While the judiciary does not take a position on the policy itself, they stated that we must again highlight serious concerns about the operational and procedural impact this bill would impose on the courts. In the testimony that they submitted, they stated that first, using a single judge to conduct pretrial screening in medical malpractice cases is not an approach adopted in other jurisdictions. They also stated that second, a system of this scale cannot be implemented responsibly without necessary resources. Even if additional funding were provided, the judiciary has testified that a minimum 1-year implementation period would still be needed. Proceeding without addressing these concerns would severely strain court operations and jeopardize the judiciary's ability to deliver timely justice. And so those were some of the things that I was hoping that we could have discussed during today's roundtable meeting so that we can reach some sort of middle ground. I will say, Senator Parkinson, that I did get a couple of calls prior to this roundtable meeting that I know that you were talking about wanting to hear from physicians. Well, some of the physicians that reached out to me, they told me that they weren't invited to the roundtable. So I'm hoping that perhaps we can have another roundtable meeting because they're off island. It's the holidays. So if you're willing, and if I have another date, maybe in January, we can reschedule another one so that we can get invitations out to physicians and I guess attorneys that might and patients that might want to further discuss Bill 82 because it truly is very important. So thank you.
Thank you so much, ma'am. Senator CITE, do you have any comments or things to say?
Well, first, I'd like to thank you and your staff for agreeing to having a roundtable. That was something that was brought up during the hearing of this bill, Bill 82-38. And during that time, I think we mentioned a couple times actually, even from yourself. But unfortunately, we're sitting here, almost just one individual, a member of the public. Good to see you, Joe. Thank you for being here. But a round table, in my perspective, as the oversight chair, was intended to bring people to the table, like my good colleague said too as well, before me, that it's a discussion on what is in the bill that would help making us have decisions on certain regulations that are put in there. You know that the bill was scrutinized for, gosh, many, many times. I think we've had like 4 roundtables. We've had at least 5 public hearings on the particular bill. So and I noticed that this bill is very similar to the bill that Senator Terlahi and I introduced. So it had quite a bit of scrutiny, but it is different now, you know. And having the same individuals coming here to testify or even discuss their concerns is very important, and that's what a roundtable is. So I have to ask Mr. Senator, who did you invite? Who did you invite to this roundtable?
We put out all the public notices and invited all members of the community to come.
Oh, just through a public notice?
Yeah.
Okay, well, I think maybe my colleague that oversees health, you know, her being here today shows just how important this legislation is.
Absolutely.
And the importance of providing the medical society to come here to testify or to provide input is very, very important in moving this legislation through. And as you know, it's in my committee, and that's why I was really glad about the roundtable. But unfortunately, I think we need to invite the medical society, and help me here, Oversight Chair of Health, who else? Medical Society, GMH, certain clinics to come and hear, and most especially those from the public, which I'm happy to see Joe is here, to come and provide input. Insurance companies, I know that we had them here at one time, as well as attorneys that were mentioned to come by and put their 2 cents in. That's the kind of think roundtable we need to discuss. I don't think it would be more than one roundtable, but this roundtable is not a roundtable. I don't think it suffices as providing enough information to put in a committee report that would really be able to school our senators and the public who reads these committee reports exactly what their consensus would be on this bill. It's just not enough information at this point. So I greatly appreciate you going through the motions on it, but a public notice is one thing, but you and I are both very busy. If I don't know that it dings me as a senator, we miss public hearings because it's just a notice. It's not, luckily it dings us. But it doesn't do that for the public, especially those who are working, especially, in the medical field. Everyone's so busy. I think that we should invite, again, and I say it again because it's so important, we should invite them directly to come at the table. So other than that, thank you.
Thank you so much. And no, I'm certainly open to the idea of having a roundtable. I didn't realize I needed to go to the doctors and make my obeisance to them for them to show up to a publicly noticed roundtable. If I got to go through the extra steps so that we can have that dialogue, I am willing to do so. I just figured that the doctors would avail themselves of public hearing notices just like any other member of the community. But it's clear that just like in the medical arbitration, the doctors see themselves as a different class that needs to be catered to in a different way. And I don't think that's very right. And that's why this reform for medical arbitration is so necessary, because everybody should be treated equally under the law. Equally under the law. We all get our public notices. This is a hot topic in our community. It's one of the most important topics. And you're telling me nobody in the medical community could deign to come down today without an invitation? I'm not sure I accept that reasoning, but I will make the effort again in the future. I will knock on the doctor's door and ask if they make house calls to public hearings that regard them. But I'm very disappointed that the medical community didn't show up today, because they are clamoring for for an open dialogue or roundtable, where here we are. Here we are. We showed up at a roundtable during the Christmas season. I came back to Guam away from my family so I could be here to do this. But they couldn't be here to do this. They were on vacation, as one of my colleagues was saying earlier. Okay, I understand. But I think that this conversation, this bill should go forward. I should have its day held in the session hall. This should be debated and it should be voted up and down, because this is a change the people of Guam are clamoring for. And so before we close this up, we have a member of the community that has come to join to speak at the round table. So please, sir, come join us. And if you have anything to say, we'll give you a few minutes to say your piece. Please introduce yourself and yeah, so please state your name for the record.
My name is Joseph Ariola from Dededo, and I came here actually in support of this bill. However, I'm very, very disappointed that it's just the 4 of us here. What I have to say should be heard by more people. I'm not saying, I believe in, you guys can?
That's another old age thing for me.
I'm used to it because of karaoke. So, after listening to you, Trina and Tello, I decided to hold back on providing my testimony. It needs to be heard by more people, okay? I appreciate you putting it on, that's where I saw it. thank you for being here. You have no idea how much I really appreciate that after seeing the three of you. And the same with you, Tello. Okay, I appreciate it. I will reserve that on the next hearing or legislative hearing and everything, if you will invite me, and I will be back with the same clipboard that I have. Okay.
Yeah. All these roundtables, at least the ones conducted by me, are open to everybody in the community and all the medical community.
Okay. So I was reminded by somebody to be here. So with that said, I'll just reserve what I have to say to the next one, and hopefully we'll have at least 100 or so people. It's what I have to say needs to be heard by a lot of people, Okay? So I'm sorry, I apologize. Okay, I appreciate it. And Merry Christmas. Merry Christmas. Okay, Merry Christmas. Okay, thank you.
Thank you so much for coming in today, sir. We appreciate your engagement. And, you know, I'm just kind of at a loss for words that we're going to go through the process of this public roundtable, a roundtable the doctors were clamoring for. This was not something that I was asking for on the legislative end, truly, but something I want to have out there so we could explore alternatives. Primarily, how do we pay for the medical arbitration of indigent patients? What mechanism are we actually going to use so that we don't have to reform the system in the ways we're suggesting? We could maybe do another step, another alternative. And maybe the doctors don't want to have that conversation. I don't know, but we will try again. We will try again. I gotta say, I'm very disappointed in doctors for not showing up today, but we'll try again. We'll try again, my people of Guam, because you deserve the best healthcare. You deserve to have your right to a jury trial protected. You deserve that if you have questions about your medical outcomes, it can be adjudicated by a neutral judge, by a jury of your peers, or a bench trial. That's something that we all deserve, because there, but for the grace of God, could go any of us when it comes to medical malpractice. That could be any of us. I could just as easily be sitting where some of these people testified and told us some of their just harrowing stories. And I do not need to wait for it to happen to me before I give a damn about it. I want to make sure that going forward, other people don't run into that same problem. It doesn't have to happen to us for us to care about it. And we should care about what happens in our community. And if we have a system that is skewed to one side too much, it needs to be addressed. Patients and doctors are citizens of this island, and they should both be treated fairly, not one side completely favoring the other and vice versa. And so with that, unless my colleagues have any other questions, I just want to say Merry Christmas to the people of Guam. Thank you for coming to, I guess, my little educational seminar about the background of it. Hopefully, if we do this again, we are actually get some participants from the medical community, you know. No excuse the second time. I don't bite, you know, so come on in. The water's warm. So Merry Christmas, everybody. And this roundtable is concluded.